Okay, as I was mentioning to all of you, first we'll deal with the posted questions. And there are a couple of questions that are frequently asked questions. I want to address those first. One is, this one is posted by Red Bin, who says, I'm on H4, I want to blog as a hobby. If I get any money from blogging due to ads or page hits, I want to take all of it and put it to charity. Is this legal on H4? That's a very interesting question. I personally think, again, there is something called de minimis payments when the payment amounts are so small that the government should not have an objection. But if you go by the book, I think what we should have you do is not get any money out of your blogging. And if it is possible to set up your payments that instead of coming to you and then going to charity, they go directly to charity, I think that would not be objectionable. Because the problem is, if the money comes to you first, it becomes income in your hands. Even if you give it away afterwards, government can claim that you have worked without authorization. Okay. Now, if you are on the phone with us here right now, Red Bin, press *3 if you are here, only for you who have posted this question. Press *3 if you are here with us. Okay. Well, I've made this clear once again that I don't see any problem with writing a blog, but do it without advertisements. And if you do advertise, then don't take the money home and then donate to charity. Instead, just let it go directly to charity. Okay, I trust that covers it. I also want to address a small issue that comes up sometimes when H4 people want to volunteer. So as long as you get no benefit out of it, whether it is money or any kind of health insurance or any gifts that have been pre-decided, I don't see any problem with volunteering. But if the volunteering involves any kind of money, directly or indirectly, cash or in kind, it can be a violation of the H1 visa. I had also mentioned on my LinkedIn article, if you go to our LinkedIn page, we have an article there about volunteering on H4. And actually, it might be illegal for the employer to take work from somebody they call an intern or volunteer, unless they are a non-profit or unless they are doing it just to train people who are working there. So while immigration law would not hurt you, Federal Fair Labor Standards Act could hurt the employer. Anyhow, that's just an ancillary comment. So since Redbin is not here, I will go on to the next question. This one is from John Petra. It says, before getting my green card, I had applied for a J1. Got my green card and also received confirmation for the exchange program. Can I participate in the program without J1? And the answer is that depends upon the sponsor. Okay. If your sponsor allows you, whoever is sponsoring the J1 program, if they don't have any problem with you attending on J1, on green card, then there is no issue at all. Okay. You just cannot attend the program on J1 because you don't have a J1. You are a green card holder. So what you need to do is call up the program sponsor and ask them, can you undertake this program on a green card? Now the next question is very, very important, and I want to spend a good 5-10 minutes going over this, and I hope Naveen is here. This is about a writ of mandamus. So the problem is this. I am on EB2, priority date is 2008, applied 485 in Jan 2012, dates are current, gave my fingerprints 2.5 years ago, background checks not cleared yet. So the problem is my 485 has been pending for 2.5 years. The date is current for 2.5 months. Background checks are not completed. Where do we go from here? Okay, well, first of all, let's try to understand what the writ of mandamus is. A writ of mandamus is a directive by a court, in this case a federal court, that requires the government to make a decision in your case if the case has been unreasonably delayed. Okay. There are a bunch of problems, procedural as well as practical, that prevent me from filing mandamus except in very rare cases. And I'll explain to you how. So first of all, remember, court can only order, even if you win the case, you file a writ of mandamus, you win the case, court can only order the government to act. They cannot order the government to act favorably towards you and approve the case, not in delay matters. So where somebody's 485 is delayed, they can't, even naturalization is delayed, they can't make the government approve the 485, they can make the government act. So first you have to prove unreasonable delay. Before that, there is actually a legal complication. In writs of mandamus, there is a jurisdictional issue that was put in by the Patriot Act many, many years ago, and sometimes it sunsets, then it's revived again. I don't remember currently what its status is. That jurisdictional provision says that because 485 is a matter of discretion, courts cannot question it, except courts of appeal, which is the next higher level courts, courts of appeal, and that too on a constitutional law or a legal issue. So not on a procedural issue. The circuits, federal circuits in United States, different regions have different circuits. For example, California comes under Ninth Circuit. Okay, so every circuit has its own little twist on how they interpret the case law. Okay, some judges are more inclined, or some circuits are more inclined to be lenient towards interpreting what they can and cannot question. Some other circuits are not so lenient and they may just dismiss your case. So first problem with mandamus is you can only get the court to order USCIS to make a decision. That decision does not have to be in your favor. Second, there could be some jurisdictional issues that can come up depending upon where you are filing the case. Where can you file the case? Well, two places for sure. You can always sue the government in Washington, D.C. because that's where the government lives. Most cases, I don't like to file in Washington, D.C. because D.C. judges are not known to go against the government that frequently. There are some policy reasons there. Second place you can sue is where you have filed the 485 and it's pending, or where you're living. So these are some of the jurisdictions where you can file a lawsuit. And choice of jurisdictions can be important because the reading of the law, depending upon the circuit, whether it's DC Circuit or Ninth Circuit or Third Circuit or Seventh Circuit, for example, which is Midwest area, like Indiana, all these circuits have they can have different approaches to how they deal with these cases. Third problem you're going to have is unreasonable delay. How do you define unreasonable? There was a case when I remember doing a case, we filed a mandamus against the government in one of our adjustment of status cases. And one of the cases I read before I filed the case was, if I remember correctly, it was a case from the Bureau of Indian Appeals. So if a tribe, an Indian, like as a Native American tribe, wants to be designated as a Native American tribe, they have to go through certain procedures through the Bureau of Indian Affairs. And the BIA was taking like 10 years in deciding the issue, and the court said even 10 years is not unreasonable. Okay, so we've had the situation. Of course, some people have won mandamus cases, but they are rare because government does not consider, courts don't consider government's delay to be unreasonable, except unless the judge is somehow in your favor, or that particular circuit has a decision that supports that ruling. Okay, so that's the next hurdle. Another hurdle, and which is very silly actually, what I have seen the government do is, if we win the mandamus, they will send me a 30-page RFE as a part of the decision, and they will try to find every excuse to deny my 485. Almost like a petulant child, like a child misbehaving. I have seen government do that. It's extremely unreasonable, extremely silly, and objectionable that a court is asking you to act and you start pouting. But you have to consider that. So I normally advise people, if you know all these things and you are willing to shell out a few $1,000s, considerable amount of money can be utilized or can be wasted, and you are ready to have a decision made against you. Only when you come to that point, you should consider filing a writ of mandamus. Don't be too quick to run to the court. The courts may not be able to do much for you. So he has a series of other questions. One question is, my job is senior analyst in the labor certification. Can I take a director or managerial job? Does it cause a problem? Duties are more or less similar, same technologies, but a few more direct people reporting. And the answer is AC-21 can be used for same or similar jobs. That's a mixed decision of law and technology. So in your case, the way you are describing it appears to me to be similar job, but let your lawyers help you with the decision. You can certainly do that. Can I switch to H-1B? You don't really have to at this time, but it's always a good idea. Almost every single one of our clients has a backup H-1B. I always tell people, stay on H-1B, something goes wrong with your 485, we can fight it out while you continue working, there's no interruption in your life, okay? Well, it's agreed that 485s don't go wrong that frequently, but they go wrong frequently enough that we want to keep the H-1B. If you switch to H-1B, do you abandon your green card? Of course not. Of course not. That's not a problem. Do I need to go out of the country for stamping? You see, if you have a gap in your H1s, you went to EAD, in order to activate the H1, you can get the approval, but to activate it, you'll have to go get visa stamping and come back. Okay. So I personally don't think that's a bad idea. And if there's a problem with the visa, you can just let go of the H1 and come back on advanced pro. Okay, Naveen, if you're on the phone, press *3. I want to take your questions first. Press *3 if you're here. *3 on your phone. Huh. I was expecting Naveen to be here. Let me just unlock the conference for a second.
The conference is now in conversation mode.
Naveen, are you here? Naveen?
Hello?
Naveen, are you here? Only Naveen.
Hello?
Only Naveen. Naveen, are you here?
No, my name is Philomena.
The conference is now in presentation mode.
Ma'am, I am not going to take any questions out of order. Please wait. I have to finish the questions that have been posted first. Okay, going on to the next question. This is from Dan CTBI. I have an approved I-140 from company A, priority date 2009. I worked with that company till June 2007, applied for 85, even though I was not working with them, and did that in April 2012. Also have an I-140 from company B, 2010 PD. I have been working there since I left the company A. This company did not retain priority date from previous I-140. That's not their choice. Believe me, you already have the priority date of 2009, even though your papers don't show it. It is automatic. Okay? You can confirm that with USCIS. You can write to them. You can even call customer service and ask to be put through to somebody who can help you, and you should be able to get a confirmation. Your priority date should be the earliest I-140 that has been approved. Okay, you received an RFE for medicals. and for employment verification letter in June 2014. Company B does not want to provide the employment verification letter until Company B's priority date is current. Please, I already answered that question. Your priority date is current if the old priority date is current. So you will port your EB3 priority date into EB2 if your second case is EB2, and your priority date will be the one that belonged to the Company A. Okay. So, and there is also no need to withdraw the 485. You can simply request the government to attach your 485 to Company B's I-140. They call it transfer. Okay. So you can transfer the 485 from Company A's filing to Company B's filing. Okay, different titles, different job descriptions of the two titles doesn't matter. So you have a list of questions. If 485 is approved, how do I know whether it is approved from Company A or Company B? You can verify that through USCIS. Okay, or you have EB2 from both of them. Yeah, you can verify that, and you can also ask USCIS to use one or the other. Okay, you can also do this. You can tell them to use Company A's I-140 and file AC-21 for Company B. If the titles are different, but the jobs are a little bit different, not too much different, so you can do AC-21 for Company B even though you have an I-140 approval through them. If I had attached employment verification letter and I-140 from Company B, will that be linked? Yeah, you can request that to be linked. You can do it anytime before approval. Once the 485 is approved, it cannot be delinked. In how much time should I leave Company B and start working for Company A after 485 is approved? If you do AC-21, you don't have to join Company A at all. Answer number 5 is automatically included. Question number 6, if Company B is okay after I get green card in my hand to still employ me under green card, but not H1, all of this is irrelevant. Just file AC-21, let your lawyers look at it. File your AC-21, you are safe. I don't see any problem with it. Okay. So some things that you should have come away with from this discussion. 1, your priority date is automatically yours. You don't have to do anything more. Your 485 can be transferred from Company A to Company B. You can ask, even you can file AC-21 for Company B. So that way, instead of giving any employment verification letters, you're giving a letter from Company B that says jobs are same or similar. Okay. So those are the 3 things that I think you should be aware of. Next question is from Raphael. Already applied for I-131. One thing is not clear. Are you doing a re-entry permit or an advance parole? So Raphael, are you on the phone? Press *3 if you are on the phone. *3 if you are on the phone. Raphael. Okay. So I'll do my best to answer this question, but I'm not clear. If you have a re-entry permit application, you can actually travel abroad after your biometrics. But if you have an advance parole, you should not travel until you actually receive the advance parole. Okay. But if it's a re-entry permit, you can actually have it sent to a US address and they can send it to you, or you can even have it sent to a consulate in your home country. Okay. So next question is Raj IMG. I have a family emergency, father in hospital, possibly terminal. I'm sorry to hear that. 45, I-131, 675, everything is pending, not traveled in 10 years. NSC took the expedited request over the phone, then denied it. Is there anything special, medical necessity form that I need to fill? No. I think if you just write to them a letter with some evidence of the fact that your father has been hospitalized and see if that works, that could be one way to do it. Okay. Can I request expediting both 765 and 131? Sure, you can. Well, it's a combo card, so they'll probably expedite both when they expedite it. But definitely 131, you have grounds for expedite. Try also making an info pass appointment and take the evidence with you, like hospitalization records, and maybe a letter from the doctor stating what his condition and prognosis are. Things like that could probably help. Okay. Worst case scenario, in case of death, what would be my choice? Well, you should not travel um, on just the without the advance parole, because H-1B visa, unless it is already stamped and you have maintained status, it's not a reliable option. Okay. Only time it's a reliable option is if you are maintaining status and you already have an H-1 visa stamp. Okay. So let me go on to the next question. This one is from, this is a long one, USCIS INS DOLGC. I have a question on porting the priority date. So the question is, if my labor and I-140 are approved, remember you can't port a priority date without I-140 approval. Just labor certification approval does not give you a priority date. Once the I-140 is approved, the priority date is yours. And if you went from being a biology teacher to a computer systems analyst, that's no problem. You can, there's no reason why you cannot inherit the priority date from a totally different profession. Perfectly legal. Next question, the question is Vinam 30. Questions are about N470. Okay. N470 was filed, check got cleared. He's working for an Indian company in, or a US company in India. So there was an earlier person in his company who also got the N470 approval after 2 rejections. Does this make any impact on my application? No, it should not. Okay. Now, I am not sure how much you know about the N470. I need for you to read the instructions. We have a couple of videos on N470 that are, I think, quite instructive. I want you to review those. I think you have some fundamental misunderstanding of what N470 is. I don't have time to go over all the details, but I'll tell you this. N470 doesn't require you to keep coming to USA, but it's good for you to maintain that. Let me take a step back. First of all, N470 is an application that protects your naturalization application from a visit outside the USA as interfering with the period that could interrupt your naturalization requirements. So let me explain to you how that works. Naturalization requires 2.5 years of physical presence, 5 years of green card. Okay. N470 does not excuse you from having 2.5 years of physical stay in the United States in the 5 years immediately preceding your application. Okay. Naturalization also requires that your stay in the USA should never be more than a year outside USA. If it is, then you have to start 5 years all over again. That is what N470 protects you against. Okay. So N470 does not protect you or isolate you or insulate you from the 2.5 years of physical presence. If you're trying to protect your green card, that is done by I-131. Usually we file both forms together. Okay. So please read up on this a little bit because I'm a little confused about what your issue is. What are you confused about? I don't think you know enough about this. I may not have all the time I need today, but at least that gives you some information. We have videos on this, and read the instructions on the form N470. Okay. IRS USCIS address change. You don't have to tell USCIS about your address change if you are leaving. IRS, I don't know what their law is. I don't think you have to inform them at all. In the tax return, which address should I put? That's something you should discuss with a CPA. But the usual rule is that you should never file a tax return as a non-resident. even though you're outside US. Okay. Next question is NKLN or NKL Nandu, I guess. I have approved I-140 from company A, priority date 2013. Approved I-140 copy I have. So you've got a copy of the approval notice. If I move to company B, you have to start again. Yes, you do. Other than the I-140 copy, do we need anything else? No, you don't. Only thing you can need is if you are going to use the experience gained with that company, you probably need an experience letter from that company. But you can automatically, the priority date has become your property. Even if you didn't have a copy of the approval notice, you would still get the priority date. So that's not a problem. So the question is, how long can I wait to start the second green card process? That's up to you. I certainly recommend you don't wait too long. Next question is from Anupama about getting a waiver as a pharmacist to take the FPGE exam. Well, I do not know the answer to this question. The question that you're asking me is not really a legal question. It is a question about the qualifications that pharmacist needs to take the exam. I have no idea. I mean, of course, we can find out, but I would suggest, just like I'm going to find out by making a few calls, you should do it yourself. So, unfortunately, Anupamaji, I do not know the answer to your question. JYO Siri wants to know, currently on H1B, I'm working from home. So you've done an amendment, H1B amendment, and you're approved to work from home. You don't have to go to client site. You can do everything from home. Now you're changing home within the same area. If it's the same county within 10, 20, 30 miles, filing an H1B amendment should not be necessary. If the client is the same, location is just 10, 20 miles, your job remains the same, and you've been approved to work from home, filing a new LCA should be enough. Okay. You should start your LCA, you should file your LCA as quickly as you can and then move. So next question is, I work for a university, so I've got an H1B visa which is CAP exempt. Can I transfer my H1B to a CAP non-exempt? The answer is no. Here is the weird thing. And this law is very odd, so try to follow. If you are working for a CAP exempt employer, and you've never had a CAP H1 before, you cannot just quit your job and join a CAP employer unless you go through the April-October cycle. Okay. However, if you have a CAP exempt H1, you can get approval for a concurrent CAP employer. So work for the university and start working at the same time for another employer. You just can't quit. Okay, so you could do it this way. You could start working on a concurrent H1, do both jobs, and then April-October life cycle, try it. If you get selected in the quota, you can then just quit the other job and do this full time. And the timing can be worked out by your lawyers. Okay. Next question, Rajesh Ramsey, PERM approved 2013. ETA 9089 2013, I-140 approved in 2014. What is my priority date? It is the date your 9089 was filed. So the way it works, Rajesh, is your priority date is the date you start your green card process by filing for PERM, but it becomes your property or it becomes fixed only when the I-140 is approved. So if the I-140 is not approved, you've got nothing. But if I-140 is approved, your priority date is the date your ETA 9089 was filed. That is when your PERM was started. Zeus wants to know, I'm from India, H1B, BTech engineer, and I'm a patent agent. So he's working for a law firm, let's say A, and he's also a director of an Indian company B. B provides services to A. Okay, and both A and B are majority owned by a US citizen. B has 5 to 6 employees. This is the Indian company. he was managing them. So I'm also a director of another company. So one of the things he wants to know is doing an L1A. But remember, to do an L1A or an EB1 through executive managerial category, you have to spend 1 year outside the United States working for a branch or a part of that group of companies. 1 year outside the US. Approach number 2, apply for a green card while on H1B. Would I apply as EB2 or EB3? You might be able to apply for an EB2, but there's some issues here. I hope you don't own any part of company A. If you don't own any part of company A, they should be okay to apply for your green card. But talk with your lawyers. This is an issue that should be handled carefully, because it does appear that you have an extraordinary relationship with the management. Okay. If I take approach 2, which is filing firm, will I be able to switch jobs without affecting my green card or its priority? No. If you switch jobs before I-140 approval, you will get nothing. If you switch jobs after I-140 approval, you'll have to start green card all over again with another employer, but you will carry the priority date. Okay. If you quit the job after I-140 is approved and 485 has been pending 180 days, then you don't have to do green card all over again. You can just use AC-21 and go to a same or similar job to any employer. Then Jayakumar V resigned from his company. H1B was transferred from current to a different employer. But after discussion with our current employer, decided to continue with the current employer. Okay, now interesting thing is, does the resignation operate as a final matter? I think it's a little bit gray, but I don't think it does. And I think if you plan to stay and they have not withdrawn your H1, you can stay with the same company. And your family who's in India and they are on H4, they can travel using the same visa, as long as you never actually quit working. If you resigned, went home and didn't work for a week or 10 days, maybe the status is an issue. Okay, and you need to go for restamping only if you lost status. If you never lost status, you don't have to go for restamping. Your family doesn't have to go for restamping. Your family shouldn't have to go for restamping unless you lost status. Okay, and the only way I can see you losing status in this situation, other than the usual ways that people lose status on H1, such as working in an unauthorized site or working in a job description different than what was given to the government. The only way you could otherwise lose is if after you resigned, you stopped working. Okay. So next question is from Vishnu Austin. Green card was sponsored by company A. Then we have a whole lot of details. I now wish to move company B using EAD. So basically asking me about AC-21. See, his I-140 is already approved in 2010. 485 has been pending more than 180 days. Okay, so he can do AC-21. What is the process? It's just a letter that your lawyers should send to the government stating that the two jobs are substantially similar. There's no particular form for it. And the information that USCIS will need is just the comparison of the two jobs. Even if the company A revokes your I-140, they cannot take away your AC-21 rights, nor can they take away your priority date. So their revocation is not going to hurt you if the AC-21 is proper. Can USCIS reject I-140? USCIS can revoke I-140s for fraud, misrepresentation, then you lose everything. And sometimes they do it 8-10 years down the line. If an RFE for an employment verification is issued, must the response be from company A or company B? Company B. If you're doing an AC-21, it will be company B. I've heard that green card is for a future employer. Do I need to go back to company A? No. If you're using AC-21, you will not go back to company A. Okay. So you will stay with company B, and that should be the end of that matter. Sunil R. Kimi was used to work for employer A, that was a consulting company. Did green card I-140 approval in 2009, but EB3. Later in 2014, switched to another US-based full-time employer B. Okay, they started perm process. They haven't filed perm or I-140 yet. I need to go to India. So I think your only concern is because I have a green card going, does that become a ground for denial of H1? The answer is no. H1 is a dual intent visa. Okay, H1 is a dual intent visa. You are allowed to have a green card going, there is no problem. When you fill out the form DS-160, you need to indicate that somebody indeed did apply for an immigrant visa for you, because I-140 is an immigrant visa. But that does not interfere with your H1 visa stamp. Okay. Next question, Ayan Kole, working for a US company on H1B, got married to a US citizen, a social marriage in India in December. She will sponsor my green card. Can I file my green card now or wait until I return to India? You can file your green card process now. So September, October, November, December, I don't know if you have enough time to get your advance parole. I would like you to travel on advance parole. So that could take about 90 days, sometimes more. So just try, maybe you should postpone everything in India until you can get advance parole. And you can do this process independently. Your company has nothing to do with it. Is it okay for you to stay in Oklahoma while wife is in New Jersey? I don't see any problem with that. It happens all the time. And I don't prefer one service center over another. I think family-based cases go to the, the benefits processing, what are the national benefit centers? They don't go to service centers. Double check that. I don't keep track of these details. Our office does. Next question is Vishu84, looking for H1B cap exemption based upon unused H1B from my present L1A status from a different employer. Okay. So 2009 to 2012, you have an H1B. But you never got it stamped. Current USCIS reading was that unless you get the H1B stamped, they don't consider you to be quota exempt. Okay. So you can double check that again, because USCIS they can change their minds so often. But last time we spoke with them on this issue, they said until you get a visa stamping, if you are getting your H1 outside USA, unless you get your visa stamping, they will not consider you to be in H1. If, however, you are in USA and you don't revoke your H1 until after October 1st, you are considered to be quota exempt. So visa stamping in that case is not needed. If I can be cap exempt, I already addressed that. Are there higher chances of rejection as you had 221G in the previous case? Well, you had mentioned that in your previous case, it was the employer that was the problem. If indeed that is true, you should not have any issue in subsequent visa stamping. How much average time the process may take? New petition by employer C. You are not H1B cap exempt as far as I can tell. Is it okay to be non-managerial for H1B? Presently, I'm on managerial role on L1A. Sure, sure. Jobs change all the time. If my present L1A stamping is valid till December, but I-94 is good till April 2017, and if I opt for change of status from L1 to H1, will I be able to stay in USA? You know, that's a difficult question for me to answer. I think if you continue working till October, there is no question. But if you quit working Can you stay? I don't know the answer to that question. I would have to give it some thought. Will I have to go for stamping after change of status? Because you are not exempt from quota, you might have to if you quit working. But if you continue working till October or September 30th, you should be able to do a change of status and go for stamping only when you go for a vacation. If at all I opt for green card process after transfer to H-1B, do I need to go for a successful stamping before GC process? No, you don't. If you got a successful change in status and you went from L1 to H1, you are not required to go for visa stamping before you can file green card. And the last posted question is from Bruni Randa. Been in 45 for almost 3 years. They first sent work employment card. I was able to obtain my license. The problem with driver's licenses, Bruni, is that it's a matter of state law. We cannot help you, nor can we make any recommendations because every state is different. Every DMV is different. You may want to contact your local congressman's office. Okay, so when you have these issues about 485, try to contact your local congressman's office. They should be able to help you at least get some resolution. I don't think a lawyer can do anything for you. Okay, let's now start with follow-up questions. No new questions. I will do new questions after we finish this. So any follow-up questions, press *3. Only from people who have posted earlier questions. *3. Press *3 on your phone, please. Am I to understand there are no follow-up questions? I hope everything is okay. All right, any questions at all, press *3 on your phone. Any questions at all, press *3. I wonder if this is even working. Okay, I'm going to unlock the conference for a second. For some reason, *3 is not showing up. Let me.
The conference is now in conversation mode.
Okay, guys, only people who have posted questions. First of all, did you guys try *3? Any of you tried *3? Stop saying hello, please. Don't say hello. Anybody tried pressing *3? Say yes if you did. Okay.
Yes, I need to talk to you, please. Hello, sir.
Hi.
Hello, sir.
Please hear me?
Okay, I cannot conduct a conference like this. Ma'am, you need to be, just for a moment, give me time to work this out. I need to proceed in a certain manner. Just hold on. Okay. Are there any follow-up questions? Say yes or no.
No.
Okay.
Hello. Yes.
Okay. Somebody.
Ma'am, my name is Philomena.
Ma'am, where are you calling from?
And
what is your?
I need to talk to Rajiv. Khanna, please.
Okay. I don't know why I'm not able to.
I have a follow-up question.
Yeah, one second. Philomena, wait. I will call on you.
Yes, sir.
I will call on you. Just wait. Okay? Just wait.
Yeah, okay. I am from India. I don't know much to talk English. So
Okay.
I need to talk in Hindi.
I can talk to you in Hindi, but you have to wait until I get to you. Please wait. Okay?
Okay. Thank you, sir. Thank you, sir.
Yes, ma'am. All right. Now, somebody said they had a follow-up question. Please go ahead with the follow-up question.
Yeah. Hi. I am Vishnu _84. And sir, you recently mentioned about the H-1B. So I just, sorry, but the voice was not clear. So can you please confirm that I am H-1B exempt?
One second. Vishnu 84, you said, right?
Yes.
Not Vishnu Austin.
No, Vishnu _84. I think this is the last one that you have.
Oh, last one. Okay, last one.
I think.
Okay,
Yeah, last
on the
one,
next
number
page.
20.
One second. Let me go on to the next page. No, that's not you. Do you know the question number, sir?
It's number 20. And it's in the first page itself, sir.
One second.
And the share number is 20.
1 second. Let me double check. I see 19. First page has only 9. Oh, yeah, I see you. It's number 19 on. Oh, okay. Okay, I see it. So you were not cap exempt because you did not get a visa stamping. Let's look at your case. When you got your H1B approval, were you in India?
I was in Europe. I was in Cyprus, not in US.
Oh, same thing. If you were outside USA, and you got your approval, you went for visa stamping, but you never got a visa, right?
Yes, that's correct.
Okay. Vishnuji, the problem is if you have never gotten a visa, the current thinking of USCIS is that you are not exempt from quota.
Okay.
Okay. Double check it with USCIS. Have your lawyers call them. But our conversation with them is less than a month old, and we've verified this on 3 occasions. We've been told every time that if the visa was not stamped, we don't consider the H1 process to be complete.
Okay.
All right.
Okay, but at least the exemption remains, right? Even though the stamping was not available or not successful, but at least the exemption should be available, right? Or
Well,
even the exemption, as you said.
we can't change the law based upon what we think is right. We have to go by what the government says. So their current thinking is, guys, I ask you all, please put your own phones on mute because I have opened the lines. Everybody, please put your own phones on mute except when you're talking with me. I appreciate it. That way we'll be able to all hear each other. And I'll talk with everybody. I will make sure I answer everybody's questions before we hang up. Okay. So yeah, Vishnu. So the answer is, I agree with you. I personally think this is an incorrect reading of the law. Once the H1 is approved, that's all. The law says approval. It doesn't say you got to go for visa stamping. But that's the reading USCIS is giving it. Okay. Do you have anything else, or can I go on to the next person?
Sorry, sir. Can you please?
Do you have anything else? I need to move on. Do you have anything else?
No other question. Thank you, sir.
My pleasure. All right, folks. Anybody else has a follow-up question? No new questions. Follow-up.
Yeah. Hello.
Go ahead.
Rajiv, sorry, Khanna.
Which number question are you, sir?
Hello.
Which number question?
Hello.
I can hear you. Which number question?
This is my question. My question is before the Vishnu's question. Actually, I missed that.
Okay. 1 second. 1 second. I am right. I am call.
Yes, sir. I don't know. Phone number is I don't know.
Are you? I am call. Okay, ma'am. Guys, there's too much confusion here. Just hang on 1 second. Nobody say hello. Are you? I am call.
Yeah, I am called.
All right. So you're getting married to a U.S. citizen, Oklahoma, New Jersey. All right. What is your question?
My question is actually I resigned from my current employer and I shifted to new employer. I plan to shift to new employer and my visa got transferred to that new employer. But after some time, I plan to stay with my current employer itself.
No.
My question is that
Hang on. You have me on the wrong question. Okay. I know who you are. Give me 1 second. Let me pull your papers. Yeah, you are Jay Kumar, right?
Yeah, correct.
Okay, so please.
Yeah, correct.
Yeah, you are confusing me unnecessarily. Your question number is 16. You are Jay Kumar. You resigned from the employer and you started an H1B transfer. It was approved, but you want to continue with the same employer, correct?
Yeah, correct.
Okay, now my question to you is, when did you resign? When did you resign?
I resigned on September 5th.
Okay. Did you stop working or did you continue working after resigning?
I'm currently working working after that. I wrote the resignation next day itself after communicating with my managers. So I convinced and wrote my resignation next day itself. I'm continuing with the current employer now.
I don't see any problem because if you continued working, I feel the resignation is an internal matter. It is my judgment that you have not violated your H1 status. So your family can travel back on the same visa. You can travel on the same visa, no problem.
Okay, you do it. I will watch
Okay.
it.
Okay?
Okay? Please try.
Okay, then back to India again. I go for any re-stamping process or if it is stamping is valid.
If your stamping is still valid, you don't have to go for visa stamping again.
Okay, sir. Okay. Thank you. Thanks a lot.
Oh, you're welcome. Good luck. All right, guys. Everybody stay on mute. Only people who have a question. Follow-up question.
This is Zeus. I want 15, question 15.
1 second, sir. Let me pull your question, okay? Question number 15. Oh, Zeus, of course. Oh, it's the good Lord. Second command, good Lord. From the Greek mythology. Yes, Zeus. So I know your situation. Company A, Company B, do an EB2, L1A managerial. Have you worked outside USA for this Company B?
Yes. For 3. So if I understand, you have to be there for 1 year in the
Yes.
last 3 years, and that condition is met. So I was there before 2013. I was in India only, and I was managing Company B in India.
Oh, give me 1 second. Let me get
But I
the,
was
let
managing
me,
company.
give me 1 second. Let me get the details. When did you enter USA after quitting from India?
On April 19th, 2013.
April 2013, you enter USA, and that is on H1 visa?
Yes.
Okay. By the way, if you are working for the same group of companies, the law requires only that you must have worked 1 year out of the last 3 from the date you entered, not from the date you apply for the EB1.
Okay, excellent. So that is met. That condition is met.
Normally what happens is you have to meet 1 year out of 3 years requirement from the date you apply for the EB1 or L1. But in your case, if you are working for the same group of companies, even if you are on H1B, we then go back and look at 3 years immediately before you entered USA, not on the date you apply for L1. Okay, so that is good. Was your role in India as a manager?
I was actually the director, so it was more than I was managing the whole company in India.
I think you have a. I
And,
think
so
I think and in USA, can you be given a managerial role?
no, here I'm not particularly a manager. I'm actually looking at a function.
Okay, no, but
So
wait.
that function being the India
Wait.
management.
There is something called functional manager also. You can look at that. I think you should
Right.
definitely, this is a possibility. EB1 is something that should be carefully looked at. I think it's a possibility.
Okay.
Okay.
Right.
What else do you
Okay.
have?
Understood. So basically, the recommendation is that I should explore this out thoroughly. In this case,
Absolutely.
the relationship between A and B is not direct. That is a major caveat. That
The
common
law
person
is
owns
the law is this, Zeus. If the same individual or groups of individuals own roughly the same percentage of both companies. So let's say you and your partner own 70-30, 70-30 of both companies. That's fine. That's good enough for a relationship. Okay. And also
I
remember,
I don't own anything in the US. I don't own anything in the US.
also remember, it is also possible the relationship does not have to be 1 year old. It is also possible for your majority partner in both companies to put his stock into a third company, and the third company that he owns 100% can own both companies. Okay. And that way you have a relationship, and relationship does not have to be year old. It can be created tomorrow, and today you can file for EB1.
Okay. Now, should I apply for EB1 under L1A or under H1B? I understand I can do it under both.
You can file
I can
for
do
EB1. I like to go L1 to EB1. It makes things a little easier, but it's not required under the law if you have a clear-cut case. Okay. Personally, I think L1A to EB1 is a little easier.
Sorry, I didn't hear the last thing you said.
I said L1A to ED1 is a little easier.
Okay, so you would recommend I take that approach now, right?
Yeah, you don't have to, but I think you should.
Okay,
All right.
I appreciate it.
You're welcome. Good luck, sir. Good luck. Okay. All right. Let's go on to anybody else has any follow-up questions?
Sir,
This is Dan PTPI for 5.
Philomena, please do not interrupt.
yes, sir.
I will call on you.
Yes, sir.
आप बीच में मत बात
Oh,
करें.
okay, okay.
आप बीच में बात करते हैं तो मेरा काम बढ़ जाता है. आप वेट करें.
Okay, okay. Sorry, sir.
मैं आपका क्वेश्चन
Okay, sorry, sir.
आंसर करे बगैर हैंग अप नहीं करूंगा. आप वेट करें प्लीज. Okay?
Sir, your friend give your.
It doesn't matter. It doesn't matter.
उन्होंने बोला कि आप थोड़ी देर म्यूट में रहो, वो आएंगे आपके पास.
मैं आऊंगा आपके साथ बात.
Okay,
प्लीज
okay.
टाइम वेस्ट मत करो, उनका भी मत करो और हमारा भी मत करो प्लीज.
आप थोड़ा वेट
वो
करें.
आएंगे आपके पास.
I'll be right with you.
Okay, okay. Thank you.
All right. Follow-up questions, guys. Follow-up questions.
DAN PTBI question number 5.
5. 1 second.
Regarding company A and company B.
Let me get to it. 1 second. Question number 5. And this was, is it Dan? Dan?
Yes, Dan PTBI.
Okay, you are, I-140 is approved. Okay, this is the company who doesn't want to file a 485 for you. They want you to, okay, got it. Yeah, go ahead, please. I know your case. Go ahead.
Actually, recently that 485 is approved before I have sent in my AC21.
This has happened to many people. You know what I do? You know what I do? Because the law is so unclear in cases like this. You have two choices. You can go back and join company A. If you can find out whether the 485 was approved through company A. It looks like company A because B's paperwork is not complete. Or what you can do is, prepare the AC21 documentation and keep it, so that if this issue ever comes up during naturalization, you can show the government that you were going to file AC21, but before you could file, 485 was approved. I don't think you'll have any problem.
Okay. And for the AC21, what document should I attach? Of course, I can search online, but just in time on phone with you, I'm asking you.
It is just a letter. It is just a letter from the new employer. But have your lawyers involved in this. Don't try to do it yourself.
No, the company lawyer is not at all involved, and he is not even willing to.
Then get your own lawyers.
Help us.
Get your own lawyers. Look around. Get a good lawyer. Get involved. Because don't do it yourself. I don't want you to be in a situation where you're going to have a problem for your naturalization. Okay?
Okay.
So once again,
if I decide to go back to company A,
right.
Sorry. In how much time I should switch the company?
I would say commercially reasonable time. I mean, normally how long does the employer give? Maybe month, 2 months, 3 months, something like that.
Okay, thank you. And how long is better for them, like 6 months or 5 months?
That I have a complete blog entry on that. How soon can I leave?
Okay.
Okay. So
sure, thank you. Thanks a lot. Thanks for this.
Review that. If something is not clear, call me back again. Okay.
Sure. Thank you.
All right. Any follow-up questions, guys? Any follow-up questions? Okay. Now I am going to start asking people in the order that they called in. Okay. So I'm going to ask you, do you have any question one by one? And if you do, please let me know. I'm asking somebody from New York, area code 917. Do you have a question? New York 917. Do you have a question? Okay. I'm going to Texas, area code 469. Do you have a question?
Yes, sir. This is Muthu here. I'm from Texas. I'm
Yes.
the 469 guy.
Yes, sir.
Okay, sir. I'm in company A right now.
Okay.
I have an EAD,
Okay.
which is 3.5 years before I got it in 2012. I got one-time extension for the next 2 years, which
Okay.
is valid up to 2050 March. Now I'm planning to join new employer. Okay.
I have a question.
And
I have a quick question. Is your I-140 already approved?
yes, approved. I got a EAD.
And your 485 has been pending, of course,
No.
couple of years.
Exact. Yes.
Okay, keep going. All right. So you want to join a new company. All right.
I want to join a new company, and my question is that I want to do AC21 because I watched your video about AC21.
Good.
My question is that when I apply my next EAD extension with the new employer,
Right.
do I need to, if my current 485 and 140 withdraw by my current employer, my EAD extension will get affected, or any RFU will I receive?
Let me clarify a couple of things. First of all, employer cannot withdraw your 485. That is your application. Okay.
Okay.
Employer can withdraw or revoke the I-140, but that does not hurt you at all. That's no problem. And it does not affect your EAD at all.
For the AC21, in case if I'm not getting employment letter from my current employer, meaning my new employer, can I do it on my own, or do I need to attach my employment letter?
You
for
have
the
to.
AC21
You have to get an employment letter. Muthu, I will very strongly recommend you read a memorandum given out by William Yates. William Yates memorandum of May 2005. May 2005. It's on the USCIS website. It's all over the web. It has very good explanation of what you can do on AC21. In fact, you can do an AC21 for your own company also. Okay.
Okay.
And just
So,
read up on that, and then if you have questions, we can take them up.
Okay, sir. One more EAD question is in my EAD extension. Will that anything to do with my meaning? Will they check my 140 validity or my 485 validity when I extend my EAD next time?
I-140 is irrelevant. 485 must be in place.
So most likely my EAD extension will not be in with any issue, right?
I don't see any issue at all. Okay.
Okay. Thank you, sir. That's one of the main questions I want.
You're welcome. Good luck, sir.
Thank you.
You're welcome. All right. I'm going to New Jersey, area code 732, New Jersey. Go ahead, please. Do you have any question? New Jersey, New Brunswick, New Jersey. Okay. Let's go to Maryland, area code 240, Maryland. Okay. Area code 210, Texas. Okay. Area code 404, Atlanta.
Hello, Rajiv sir. How are you?
Good, good. How are you, sir?
I'm good. I'm your Facebook friend.
Yeah, I see your name on the caller ID. I know who you are. How are you?
Yeah, I'm good. So recently, my dad did a renewal for his H1.
Okay.
And my mother and my younger brother, they got the renewal too. But the problem is, my dad got the renewal till 2017, but my mother only got the renewal till 2016, and my brother is turning 21 in 2016, October 17, 2016. Okay. But what I don't understand is why didn't my mother got till 2017?
Because they obviously,
the renewal.
It looks like a mistake. It looks like a mistake. What you need to do is look at the H1 papers that were filed with the government. If the papers ask for 2017 or whatever time they ask for, or there is no mistake in the paperwork, you can actually have your lawyers contact USCIS and tell them they have made a mistake. They will reissue it with 2017 date on it.
Okay, but I think that while filing for I-539, I think that they mistaken on the expiry date for my mother. That is what I think.
Then you
But
can't.
the explanation in the
Then you cannot do anything. If you made a mistake on the forms, the only way to extend it is to go back and file another I-539 when the time comes. You're not going to lose that time. You can always extend it later.
Okay. Okay. And my last question is, since we all know right now that the immigration reform is going to happen after November, maybe, but in this case, what are the documents are they going to require to verify that the immigrants who are here, undocumented immigrants, are here more than 5 years or more than before 2012?
Let me kind of give you a quick word on this. I don't think Obama can legalize people. He can do what he did with under DACA. He can postpone legal action on people, but he cannot make them legal. So if you want to know what kind of documents, just look at the instructions on DACA. It will be the same kind of documentation. Okay?
Okay, but since, okay, thank you. I appreciate your help.
You're welcome. Philomena ji, are you here? Philomena?
Yes, sir.
Haan
Yes, sir, I am.
हाँ जी बोलिए बोलिए.
Good afternoon, sir. Good afternoon, sir.
Good afternoon ji.
Sir, I have a problem for my visa and
आप मेरे साथ हिंदी में बात.
मेरे को बहुत सारे प्रॉब्लम था काम का जगह पे.
जी बोलिए.
हेलो.
क्या प्रॉब्लम है बोलिए.
They were not giving food, eating, everything, and somebody, किसी ने मेरे को हेल्प करके किसी लॉयर के पास लेके गई. उन्होंने मैं रात को सुबह से 6 बजे से रात को 12 बजे तक काम कर रहा था, लेकिन इन लोगों ने मेरे को ना पैसा दे दिया ना कुछ. बाद में लॉयर का बातों से उन्होंने थोड़ा पैसा दे दिया, आधा पैसा लॉयर ले लिया, आधा मेरे को दे दिया.
अच्छा फिलोमिना मैडम एक सेकंड मैं आपको अपना फोन नंबर दे रहा हूँ. आपकी जो प्रॉब्लम है पर्सनल है, इसको मैं अलग से बात करना चाहता हूँ, कॉन्फ्रेंस पे बात नहीं करना चाहता हूँ. आपके पास
मैडम आपको ऑफिस में भी बुलाया था, ये नंबर तो आपका नंबर दे दिया. तो प्रेम
मैम कैन आई गिव यू माय फोन नंबर प्लीज.
पढ़ें.
अपना फोन नंबर देता हूँ आपको, अभी कॉल करो मेरे को.
अभी
मैं आपको अपना फोन नंबर दे रहा हूँ, आप मेरे को अभी कॉल करो.
ओके सर, आई हैव टू गेट द पेन.
आ जाओ, पेन लेके आओ प्लीज.
आई डोंट हैव एनीथिंग इन माय हैंड, लेट मी गो गेट इट.
जी बिल्कुल, दैट्स फाइन. Guys, I'm going to call the conference to a close. I'm just going to give her my phone number. Thank you for being here. I appreciate the opportunity to be with you. And I'll see you again in 2 weeks again, next Thursday. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.